to talk about today. Thank you everyone for joining us. I bet a lot of you were here with us for the part 1 of our tenants rights training last week. So this is part 2. And today we're going to be focusing on reasonable accommodation. We are joined again by David from Legal Aid, and we have Brian with us from HSA, who's just going to say a little hello.
Awesome. Thanks, Lily. Good morning, everyone. I'm Brian Eggers with the Human Services Agency. I've gotten to work with many of your agencies over the past couple of years, so thank you to your agencies, and thank you all for being here. I know you all are extremely busy. That's an understatement right now, so thank you for finding the time to carve out today for our community training with Homebase. And again, thank you to David. I wasn't able to attend last Friday's training, but I heard high praise from my colleagues. So thank you for being here again. Provide your knowledge and information to folks working with people experiencing homelessness and hopefully moving into housing as quickly as possible. And just a huge thank you again to everyone. I get to see some of the data on the back end, and it's incredibly impressive that folks are still finding housing despite many challenges and despite a pandemic. So thank you all for being here, and yeah, I'll pass it back off to Lily.
Thanks, Brian. Yes, here. It's amazing anyone's doing anything right now, especially the stuff you guys are doing. So, and same to you, David. So hopefully today will be a good one. We have 2 hours scheduled, but we have about an hour and a half of content. So a little extra padding in case there are lots of questions, or if not, the Friday gift of a little time back. But hopefully we'll help, this time commitment here will help save you time and help you be more effective and more strategic in the work that you're doing. So hopefully it will be that time well spent. So just to start with a couple logistics, we're recording this training today. If you have any concerns about that, please feel free to use the private chat function and let Monica know, or myself. But that's so folks can reference it later. I think everyone, this is all, you know this stuff, but if we can ask everyone to stay on mute for the most part. If you do have something that you want to say, feel free to unmute yourself to hop on, but just to default to mute would be great. And you can definitely use chat either to me, to Monica, to David, or to the whole group. If you have questions or you have a comment, follow-up, stuff like that, feel free to do that. And then with I guess just, we sent out a call. If folks have any specific issues that you're dealing with around reasonable accommodation, there'll definitely be opportunities for us to take a pause and talk through. We can't workshop the nittiest grittiest bits probably, but we do want to really make sure that you guys are getting answers to questions that you have. So if you do have a situation that's come up, or if something dawns on you as we're having this conversation, feel free to note that you have a question in the chat box, or take advantage of the opportunities that we will take where David will pause to make sure that you're getting those questions in, because we want to help workshop those to the extent that we are able to today. So with that, I'm going to go ahead and turn it over to David. David, again, for those of you who weren't here last week, is an attorney who's been doing legal aid work for 20 years. He's been at Bay Area Legal Aid, the Law Foundation of Silicon Valley's Mental Health Advocacy Project, and he's been at the Legal Aid Society of San Mateo County for the past 10 years. So he's got plenty to share. He's seen probably most of it, if not all of it. So thank you again, David, for being here, and I'll go ahead and turn it over to you now.
I have seen a lot, but there's always something new every day. That's what makes this work interesting, is our clients, the people we work with, right? So Lily, thank you for that. Brian, thank you for that. Thanks for hosting me. And thanks to everybody for joining this Friday morning. I'm gonna pull up my PowerPoint in a minute. Sorry for last week's technical difficulties, made some changes, hopefully less issues this week. And please don't hesitate to go off mute and butt in and ask a question or a comment or anything. And we'll try to answer questions. We've got some questions in advance from people, and that's helpful. We'll cover those. And yeah, don't hesitate to put a question in the chat, or like I said, go off mute and ask me. I have no problem with that at all. But with that said, let's see if we can get the PowerPoint up. Let's get the right one. All right, can everybody see that okay? All right, got the thumbs up from Lily, thanks. Let's see if we can scroll this week. Of course not, the first slide doesn't scroll, so I'm gonna go straight to Plan B, which is PDF version of the PowerPoint. So you get a little stuff around the edge. But anyway, there's our contact information for Legal Aid Society of San Mateo County. Anytime your clients, your people need legal help, you can refer them to us. And if it's a housing case, we have a housing intake line. If it's something else like public benefits or access to healthcare or whatever, you can send them to our main line. And as I said last week, and I'll say again, you can always, you all can always call me anytime you want to talk about a case or some situation going on with the client with the housing, and we'll try to either help or get a referral to the right place. All right, let's see if this works. Yay. All right, today, quick introduction to what legal aid does regarding housing discrimination and reasonable accommodations. That's the main topic for today, reasonable accommodations for people with disabilities. And we're going to cover, some hypothetical situations that come up and kind of go through those. And yeah, that's our focus for today. So just a real quick recap of what legal aid does for our clients that have disabilities. Again, our housing team mission is to prevent homelessness. Our goal is to keep people in their homes, not let them become homeless. I think that's the best solution to the homelessness problem. Just don't let it happen in the first place. And also try to help tenants in place maintain stable and safe and healthy, affordable housing. So regarding accommodations, we will help tenants request accommodations. We'll help the tenants get letters from the healthcare providers to support those accommodations. We'll advocate for the tenant to get the accommodation they need and that they're requesting. We'll advocate against eviction notices related to a person's disability. And if it gets to the point where it's an eviction case in court, we will represent eviction cases in court where the landlord's failure to grant an accommodation is a legal defense. So we'll get into all of that as part of the presentation today, but I want to let people know that helping people with disabilities and accommodations for them is a big part of what we do. So just a quick recap about what we're talking about here. Reasonable accommodations falls under a form of housing discrimination, and that is it's discrimination against a person with a disability to not grant them an accommodation that they need. So just a quick recap on what fair housing laws are about and what discrimination is about in the housing context. California has the Fair Employment and Housing Act. The federal law has the Federal Fair Housing Act, or now it's the Federal Fair Housing Amendments Act. There's other state and federal laws that provide protections for people with disabilities. So there's lots of laws out there to go off of. In general, what they do is it prohibits discrimination in housing. And discrimination is treating people differently in a negative way because they're a member of a protected class. And one of those protected classes is people with disabilities. Discrimination is also denying a person equal access to live in and fully enjoy housing because of their status in a protected class. And moving on. So again, last week I pointed out, I want to point out again, fair housing laws apply to landlords. So it applies in the landlord-tenant situation, but it applies to just about everything else that involves housing. So anybody involved in housing is subject to the fair housing laws. The housing authority, the government entities involved in housing, property managers, real estate agents, banks, insurance companies, et cetera, et cetera. So just want to be clear, the fair housing laws are very broad in their protections. So again, the protected classes under the fair housing laws, this is most of them. People with disabilities, what we're covering today, but protects people based on race, skin color, national origin, ancestry, families with children, marital status, religion, sex, gender, sexual orientation. These are all the protected classes under the fair housing laws. But today we focus on people with disabilities. The first, to be protected by the law, you have to be a person with a disability. That's the law defines who a person with a disability is that gets the protection. So there's a legal definition. So disability is a word that can get thrown around a lot. We use impairment, disability, disabled. The federal law still uses handicap. I think handicap is a pretty outdated term at this point, but the law started in the 60s, and handicap was a word commonly used in the 60s, and they just never changed it out. But anyway, the legal definition is if a person has a physical or mental impairment that limits one or more major life activities. And some of the examples are, major life activities: seeing, walking, breathing, working, learning, having relationships with other people, communicating, whatever major life activities people use day to day to get through life. If you have a medical condition that limits one of those activities, you fall under the definition of disability that's entitled to protection under the laws. You do have to get verification from a medical professional, usually a doctor, but not necessarily a doctor. Could be somebody else who's familiar with your medical condition. But if there's any question about whether a person is disabled under the law and is entitled to protection, the doctor can verify the disability, and that's pretty much the end of the story. As a technical matter, definition disability also includes if you have a record of being disabled or if you're perceived as having a disability. So it's not just necessarily having it, but you can't discriminate against somebody just based on perception of them being disabled. So with that, let's jump into our first quiz to keep you semi-engaged here this morning. So I've got some hypotheticals, a couple of questions, multiple choice questions. We'll go through the hypothetical, and then I think Monica's gonna put up a quiz on your screen. So the first one, our tenants are Amy and Beth. They're sisters, they share an apartment. Amy has severe OCD, obsessive compulsive disorder, and it is difficult for her to leave the apartment because her routine to leave the home takes too long. She works for a high-tech company coding software programs from her computer at home. Beth, her sister, is blind, but she has no problem getting around all over town. She has a guide dog, seeing eye dog, a guide dog, and she also gets the help of others. And though she's blind, she's quite a singer, and she makes a living as a professional singer. So that's our hypothetical. So we're going to go to our questions about whether Amy and Beth are going to qualify as people with disabilities entitled to protection under the law. So the first question is Amy a person with a disability as defined by law? And the second one is Beth a person with a disability as defined by the law? So take a minute to answer the multiple choice question.
Great, so folks should see a poll on the middle of their screen, and we see that we've got some responses coming in. We'll see if we can get to 50%. And we'll give folks just another 5 seconds to chime in here. Alrighty, let's see how we did. And David, are you seeing the results?
I do see the results.
Great.
And people did great. Let's just go over the answers real quick. Is Amy a person with a disability as defined by law? So the answer is yes, though she can work. Being able to work or not work is not the sole defining definition of a person with a disability. There's other major life activities that Amy has a hard time with, and so she, and basically that's, you know, getting out of the house is certainly a major life activity. And I actually had a client that fit this description. A lot of my hypotheticals are based on people I've helped in the past. So yes, Amy is a person with disability, and Beth is blind but gets along fine with her seeing eye dog and help from others and has a good job and everything. But seeing is still a major life activity. There's a lot of limitations Beth has due to the loss of her sight. So yes, she's still protected under disability laws. Now, as we'll see coming up, you don't automatically get accommodations just because you're disabled. You have to have a need. There has to be like a problem and a need. So we will move on to, you know, what are we talking about when we say a person needs an accommodation or a reasonable accommodation of their disability? So we'll talk about what is that? So a reasonable accommodation it's a change or an exception in rules, policies, practices, services, procedures for the tenant when the change is necessary due to their disability, and it serves the purpose of affording that person with the disability an equal opportunity to use and enjoy a dwelling or home. So when the disability gets in the way of the person enjoying the home, maybe it threatens them with losing the home completely, or threatens where they can't use that home, or they can live there, but they can't enjoy it like they should be able to, that's when they can seek an accommodation. So we'll be talking about this for the rest of the morning. And my little note at the bottom, reasonable accommodations are powerful tools that allow people with disabilities to obtain and maintain housing that works for them. It's quite often that when we're helping people, tenants with problems, the problem might seem kind of difficult and challenging, but when we recognize that the problem is related to a disability we have, and we raise that as an issue with the landlord, as we'll see later on, landlords have to engage. They can't just ignore that issue. They have to engage, and it forces everyone to try to figure out a solution. So some of the commonly requested accommodations that we'll be thinking about this morning, the ones we see most often, I would say, emotional support animals and service animals. We'll talk about how there's no extra rent or fees charged for them. Tenants who have behavioral problems, I'm often requesting what I call a probationary tenancy for them. We'll talk about that a little bit more, giving them a second chance to correct their behavior. Sometimes the accommodation is just getting more time to meet a deadline or to comply with a notice or a warning or something. Disability might, cause them to address things slower. Sometimes it's more time to move out. Sometimes the tenant does need to move out, but sometimes their disability again makes it harder for them to move, and the process takes longer, and so they might be entitled to more time to move out. Of course, we like to try to keep people in their homes, but sometimes they move for various reasons, of course. Live-in aids are a form of accommodation. Some people need an extra person in the home to help them out, and live-in aids can be a form of accommodation. There can be economic accommodations in the form of co-signers on a lease or payment plans to get out of a debt. But accommodation is never that the tenant with a disability doesn't have to pay a legal obligation that they otherwise owe. So the person with disability can't say, well, I don't have, I can't work because I'm disabled and I don't have enough money to pay the rent. So as an accommodation, I shouldn't have to pay the rent. I'm sorry, that one doesn't work yet. And as the last note there says, anything else that is necessary because of the disability and is reasonable can be an accommodation. Requests for accommodations are very specific to the tenant. They're very specific to the medical condition and very specific to the circumstances that are being discussed, and the solutions are tailored to all those special circumstances. So there's not very many cookie cutter accommodations, as we'll call them. I should add to my list here, because it's pretty common, is parking spaces. People with limited mobility might be entitled to a parking space that's closer to their unit, even though it doesn't fit with the normal parking policies for a building. But that's another common one. All right, let's move on. So somebody else, not me, came up with this great, I think it's called a mnemonic, the DANCE, D-A-N-C-E, for remembering the elements of an accommodation, the steps to go through for seeking a reasonable accommodation. So remember the dance. D is for disability. Does the person have a disability? A for accommodation. Request the accommodation needed. N, the accommodation has to be necessary. It's got to be related to the disability and needed to help the person keep the housing or do better in the housing. Cost is the C. C is for cost, and the cost to the landlord or the housing provider cannot be excessive or burdensome to the landlord. Can be some minor costs that are part of doing business as a landlord, but can't be excessive. And E is the tricky letter here, but to finish out the dance mnemonic here, we had to come up with an E. Well, not me, but the person who came up with this. So E is for exceptional. The request for accommodation cannot require a major or exceptional change to the landlord's, business. And we'll talk a little bit more about what that might mean. But when you're thinking about, you got a client with a disability and a housing problem, think about the dance for whether they might qualify. So let's cover some of these, cover the 5 steps in the dance. Step 1, D, establish disability. So like we said, like where we started this morning, first thing is the question is, does the person have a disability that's covered? And the way to do that is to go to a medical professional and ask the medical professional, the doctor, could be a nurse who's familiar with the person, could be a therapist, could be a counselor, could be a psychologist, whoever the medical professional is that's familiar with the person's condition, writes a letter or a note verifying that the person does in fact have a medical condition that qualifies as a disability. So the doctors rule the world of reasonable accommodations, I like to say. What the doctor says goes. Now it is possible for the landlord to get their own doctor and examine the person and challenge it. That doesn't happen very often, but it's, in theory, it could happen. Or if you get into litigation, that would be more likely. So the question comes up of what does the person with the disability have to disclose to the landlord or the housing provider? And the answer is, the 2 points here is that the tenant does not have to disclose the specific diagnosis, the specific condition, medical condition. They don't have to give that up, but they do have to give up the symptoms, the consequences, the symptoms, the effects of the medical condition to show that the accommodation is needed and it's related to the disability. So, a person might be limited in mobility, but that could be from a number of things. It could be from a traumatic injury. It could be from something like cerebral palsy. Lots of conditions can affect mobility. The tenant doesn't have to give up the specific diagnosis, the specific condition, but the doctor's going to say, because of that condition, the person can't walk, or the person can't lift more than 10 pounds, or the person can't, stand more than 15 minutes, or whatever the actual symptoms are and the condition is. So, do we have any questions yet, Monica? Let me know if I haven't been checking the chat. So just Monica, let me know if somehow let me know if I have questions that I'm missing.
No worries. We're not seeing any yet in the chat, but we were actually wondering for cases regarding invisible disabilities, disabilities that aren't immediate apparent. Do you have thoughts or advice for clients who might feel hesitancy or discomfort regarding disclosing their disability and how to navigate that?
Yeah, that's a great question, because that comes up a lot. We're talking about invisible medical conditions. We're often talking about mental health conditions. Not always. There's physical conditions, internal also, where that's true also. But often it's the mental health conditions that are not obvious to people from the outside. In that situation, I mean, if you want to request the accommodation, you do have to phrase it as, I want an accommodation because I have a medical condition, because I have a disability. So you do have to disclose that you have a condition. Now, you don't have to disclose that you have depression or PTSD or bipolar or schizophrenia, or go down the list of serious mental health conditions. You don't have to disclose that specific diagnosis, but you have to disclose enough to get the accommodation, to support the need for the accommodation. And your medical professional, probably more than ever, you're going to have a letter from somebody to support it, rather than just your word when it's not obvious at all. In fact, we're calling it invisible. So when you get the letter from the psychiatrist or the psychologist, well, that necessarily gives away that we're talking about a mental health condition. So it's often the first question you have with the client is, well, this is, if this is related to a medical condition, do you want to raise that? And they have to decide, do they want to raise it and use it or not? Because they might say, you know what, I don't want to bring that up. And that's their business, that's their right, of course. So yeah, so very good question. It's the threshold issue, is does the tenant want to use and bring to the surface and bring out in the open their condition? Not all again, not the specific diagnosis, but people are going to figure certain things out. Going to the next slide. The next letter is A. A is for accommodation. So the second step is if the person needs an accommodation, then they have to identify it and request it. The landlord is not required to figure it out on their own or take the initial step. The person, the tenant with the disability, has the obligation to take the first step in identifying the need and requesting it. So, the request for accommodation can be done in a lot of different ways, but of course the best way to do it is to put it in writing and deliver it to the landlord in a letter form, or at least an email, or something where you can confirm that the landlord actually got the request. You don't want to get a month down the road and the landlord says, I didn't get your request. I don't know what you're talking about. So, first things first, you got to put the request for accommodation out there. Second point, there's not magic words. You don't have to use the words reasonable accommodation to make it officially a request for a reasonable accommodation. You can use other language. I have a medical condition. I need this to continue living here. Can you provide it to me? That's, has the same effect. You're requesting an accommodation. but it's always best to include the words reasonable accommodation and request for accommodation, because those are the magic legal words that eventually come up if there's a dispute, if there's a legal dispute, or whether the tenant is entitled to it. A lot of landlords have come up with forms, reasonable accommodation forms. The ones I have seen seem to have been done appropriately. Their legal staff probably went over them, made sure they didn't ask too much, didn't ask the wrong questions, they asked the right questions. It asks for verification of a disability. It has a place for a doctor to sign off. It often includes a second page with the definition of disability under the law, so that the doctor can can read that and verify if the person qualifies. So in general, I don't have a problem with those forms that the landlords use, the ones that I've seen. In fact, sometimes I use them because I know if it comes from the landlord, there's a good chance that it's going to be accepted without question. So let's see, what's next? So thank you to those people who sent in some questions in advance, and I want to cover some of those now. And the first one, it's very, very common these days for people with disabilities to have service animals or emotional support animals. So let's talk about those right now, because it's quite common. First question was, what's the difference between an emotional support animal and a service animal? So it's actually more than just semantics. In general, a service animal is trained, has special training to do something, to do an act that helps the person. The seeing eye dog for a person who's blind is the classic example of a service animal. The seeing eye dog can be trained to do all kinds of things, to guide a person down a street, to stop at a red light, to go on a green light, to, et cetera, et cetera. Warn the person of, danger or trouble. So service animals are ones that are actually trained. Within the house, I've heard of animals that can like alert the tenant, like the animal perceives something that the tenant doesn't perceive, like maybe a phone ringing or a doorbell ringing or a fire alarm going off, smoke alarm going off, and can alert the tenant to that. And that's like again, that would be like a service, that's a service animal because they're trained to do something specific. The emotional support animal, on the other hand, can be completely untrained, but a cat or a dog or a rabbit or a guinea pig, mice, rats, snake, you name it, lots of animals can be just provide emotional support to a person. And so, I mean, it's very common knowledge and accepted that, a dog or a cat, like for somebody with depression, especially someone who's kind of lonely and doesn't get out a lot, doesn't have a lot of relationships, you add a dog or a cat to their home, and that can provide a lot of emotional support. It's not really disputed anymore in most circles about the good that emotional support animals can do. So basically, the emotional support animal is just that. They're not trained to do anything specific. They just are a companion. Sometimes they're called companion animals because they're just a companion to the person with usually a mental health condition. Interesting side note, the airlines have been struggling with how to handle emotional support animals that people want to bring onto airplanes. And it's gone kind of back and forth, up and down. And I heard just recently they were cutting way back on the types of emotional support animals that will be allowed on airplanes. People, I think, were bringing on some animals that were not compatible with the flight. But that's an aside. Nobody lives on an airplane, so the fair housing laws don't apply in that situation. That's more like ADA laws, Americans with Disability Act laws, apply in that situation. And I will move on from that example. So again, next question, do I have to pay a pet fee for my animal that I have as an accommodation? The answer is a strict no. Landlords can't charge extra rent. Like sometimes they charge pet rent for someone with a pet, but a service animal is not a pet. It's not considered in the category of pet. So you can't charge extra rent. You can't charge extra deposits. You can't charge extra fees. But of course, or not of course, but the tenant is responsible for any damage that the animal does or any extra expenses that the animal in fact causes. And the tenant is responsible for, generally the tenant's responsible for the cost of an accommodation, not the landlord. So they can't charge extra fees automatically. You can't assume that the animal is gonna do damage, but if it does, the tenant's responsible for paying for the damage. Let's see, third question. Another good one. What if I submit a request for reasonable accommodation for emotional support animal and the landlord does not respond? Well, we go back to step one. When you request the accommodation, make sure the landlord has received it. Make sure it's in writing. Make sure, if you need to send it certified mail to prove it arrived. If you send it an email, make sure you get a reply so there's a confirmation that the request was received. So first things first, before you accuse the landlord of not granting your accommodation, you got to make sure they received it. For, again, as I said, service animals, emotional support animals are well supported in the law now. So I think it's safe that if the landlord's just ignoring your request after a certain amount of time, depending on the circumstances, and maybe a second request or third request to the landlord, still no response. If the person needs the animal, they, for medical reasons, then they should take in that animal to help them. And of course, my last point says, call legal aid when the landlord acts surprised and upset that you now have an animal and you're living in the home. So, because as we know, that's unfortunately what happens. What's not said here, but an important point to cover that I think comes up a lot is a person with a disability who has a support animal or service animal and they're moving into a new apartment or they're applying for a new apartment, the question always comes, they always have to ask themselves, do I tell the landlord up front that I have the animal, or do I not tell them because I have a legal right? It's not a pet. Do I just worry, do I not tell the landlord and I just move in and worry about dealing with it later after I move in? There's no yes or no answer to that question. The tenant has to decide how to handle it. The tenant has the legal right to the animal as an accommodation. Again, assuming it's supported by a doctor and it's a reasonable animal. But some landlords will still discriminate. They just won't do it overtly. They won't say straight out, I'm not going to take you because you're disabled and you have an animal. They'll say, oh, someone else took the apartment. Oh, I rented it to somebody else. Oh, I changed a plan. My sister's moving to town and I'm going to give her the apartment. There's lots of ways to discriminate without coming straight out and saying it. So that's why some people with service animals, companion animals, will not tell the landlord and they'll just move in with the animal. The landlord finds out later, and then the tenant says, here's the letter from my doctor, I have the right to have this animal. And you hope that the landlord backs off at that point. And if they don't, then you seek help from you or me. So it's a tricky, sticky point for tenants with their companion animals and service animals, but they do have the legal right. Just dealing with it in reality still can be tricky. All right, I hope that answered the questions on support animals. We'll cover a little bit more, I think, as we go. And please bring up questions. In fact, I know there was another question about what happens when the support animal goes wrong. We'll talk about that also. But let's jump into another hypothetical and a quiz to get you thinking about what we've been talking about so far. So in this hypothetical, our tenants, Amy and Beth, they did not tell the landlord about Beth's service dog or guide dog. When they moved in, they decided better to ask for forgiveness than permission when they moved in. The landlord does have a no animals in the building policy in the lease. When the landlord finds out about the dog, he serves Amy and Beth with an eviction notice because he's not happy that they have the dog. And the landlord gives them a bill for pet rent for $50 a month for the 2 years they lived in the building. So they get a big fat retroactive bill that the landlord's calling pet rent because he's mad that they had a dog the whole time. Amy and Beth do not want to move out of their apartment. And let's see what questions we had to go along with that hypothetical. Monica's going to put up your poll questions. Number 1, will the landlord be able to evict Amy and Beth based on that eviction notice that was served on them? Number 1. And number 2, what's the best thing Amy and Beth should do at this point in the process? Go ahead and take a minute or so to answer those questions.
Great. Thank you all so much for participating. We are seeing responses come in. We'll give folks just another 5-10 seconds to weigh in here. Alrighty. And are we seeing the results now, David?
I do see them.
Great.
Great job by the participants. And as I said last week, all my questions are trick questions, so I try to throw in a few tricks for you. So will the landlord be able to evict Amy and Beth based on the fact they have a dog they didn't tell them about and there's a no animals policy? The answer is no. So Beth is allowed to have a service animal. She's sight impaired, so there's no doubt she has a disability. You know, a guide dog for a person who's blind is an obvious need, undisputed need for that person. So shouldn't be any dispute that they can get out of this eviction notice. What's the best thing they can do? So the best answer is C. Give the landlord the letter asking for an accommodation, the disability, and the support for the dog. That's the best thing the person should do in this situation. Then turns into a legal right once they do that. And I mean, they're asserting their legal right. They always had the legal right. When they assert their legal right, if the landlord's wise, the landlord will back off at that point. B, find a new home for the dog so they can't be evicted. Well, that might work, but it certainly would not be a good option for Beth to not have her service dog. So it might solve the short-term problem of the eviction notice, but it wouldn't be a good option for Beth. So thank you for doing that quiz. Let's continue the dance. The step 3 is N. Accommodation must be necessary. So the person with a disability has to establish why the accommodation is necessary for them, why they need it to continue living in the home or to enjoy living in the home. There's got to be a connection between the accommodation that's requested and the disability. That is, whatever the problem is that has come up is, related to the symptoms of the disability. So again, we talk about tenants got to get the support from the doctor. There is an exception in some cases. From outward appearances, it's obvious that a person has a disability and meets the definition under the law. A person with certain physical conditions and they use a wheelchair to get around. That's one common example of someone who probably obviously falls into the definition. And in that situation, they might push back and say, I haven't seen a doctor for this condition for many years. Not currently seeing a doctor. So I don't have a doctor who can write a letter. It's obvious I qualify. And that might be the exception to the rule. If the condition is so obvious, they shouldn't have to get a doctor's letter. So step 4 in the dance is C, the cost. So cost must be reasonable. So we always talk about the perspective of the tenant and what they need, and the relationship of the accommodation to their disability. But let's shift to the landlord's perspective for the last 2 letters in the dance. The landlord has rights here also. And that's where the word reasonable comes in. That's why we say reasonable accommodation. It's got to be an accommodation that is reasonable under the circumstances. And usually that means reasonable for the landlord or the housing provider. So the first step in reasonable is the cost. If there's any cost to the landlord, that cost has to be reasonable. It can't be an undue financial burden for the landlord. Now, like we said earlier, there might be some, small administrative costs for an accommodation. The landlord might have to, as part of doing business and renting to people, he might have some administrative costs of granting an accommodation, but it can't be a significant burden on the landlord. And again, as we said, for accommodations, and we're not talking about modification. A modification is when a person needs a change to the physical structure of the apartment or the housing. And that's kind of a different category of disability rights. But for accommodations or modifications, it's generally the tenant's obligation to pay for them, not the landlord's. So, what's an undue financial burden? There's no set dollar figure. It really depends on the circumstances. How big is the housing provider? How big is the complex? How much is the cost in relation to, the cost of the overall, financing. So it's really going to depend. It's really a case by case basis. If the landlord responds, sorry, I can't do that. That's going to cost us too much money. It's not the end of the story. Landlord should engage in what we call the interactive process to explore other options. Are there other less costly, less expensive options? And if there are, then the tenant might be entitled to a different accommodation than they originally requested. But it's not supposed to be just a flat no. It's supposed to be a back and forth to try to find the solution to help the tenant keep their housing or enjoy living in their housing. Step 5 in the dance is the letter E. The accommodation cannot require a major or exceptional change to the housing that's being provided. So whatever the tenant is requesting can't be a fundamental change in the landlord's business. I saw one example is, most housing doesn't provide any kind of transportation for the tenants. So tenant can't ask for the landlord to provide transportation as an accommodation for the disability as part of the housing, because that's just not something that landlord does. That's a complete change in what the landlord provides. Most landlords just provide the physical building, not services that go along with it. Now, there are certain types of landlords, maybe senior housing, for example, that might provide transportation, but in most cases, that's not the case. So, an accommodation has to be within the nature of the business that the landlord is providing. So, yeah, the example below is not really an example at all. Just as you can't ask the landlord to go completely outside the scope of the program. That would be extraordinary for what that landlord's doing. So again, these things are very case by case specific. But those are the 5 steps in the dance. So let's go on to another hypothetical and some questions to talk about that. We've taken care of Amy and Beth, so we're going to move on to our tenant client who is a veteran. So Roland is a veteran. He has a mental health disability. He has PTSD, depression, and anxiety after serving in the military in the Middle East during active duty. He now lives in housing for veterans, subsidized by the government. Roland lives in an apartment near the trash dumpsters, unfortunately. And sometimes when the big trucks come through, they make loud noises and banging. And sometimes that triggers Roland's PTSD. One time Roland had a flashback to his combat days, and he attacked another tenant who he perceived to be an enemy combatant. The landlord, of course, wasn't happy about this conflict, and he served Roland with an eviction notice for violating the lease by attacking the other neighbor. Again, most of my hypotheticals are based on clients that I've helped in the past, and you might have had similar clients with similar circumstances as this. So that's the hypothetical facts. Let's go to the questions related to Roland's situation. Question number 1, what accommodation should you request for Roland? And number 2, what other accommodation can Roland request? Take a minute or so to answer those.
Great, and we're seeing a number of folks respond. Let's see if we can just get ourselves a few more. We'll give you 5 more seconds to chime in here before we close out. All right, let's share the results.
Thanks, Monica. And my questions are maybe too easy this morning, or you guys are really good about this area of the law, probably because you've probably helped a lot of people with similar circumstances already. So people are doing great on getting the right answers. What accommodations should we request for Roland? Yeah, in these situations, really what you're asking for is a second chance. And asking for a second chance should usually include a suggestion or a solution for why this isn't going to happen again. What Roland did by attacking another tenant is already a lease violation, and the type of lease violation that will usually get a tenant evicted, certainly under normal circumstances, will get a tenant evicted if you actually physically attack another tenant or another person. But that's the point of accommodation law, is that Roland served his country, he gave up his health for his service, and now he lives in housing for veterans. And this is a situation where the law says he deserves a second chance. But the person can't continue to attack people. That's not a good option. So we combine the give them a second chance, and here's what we'll ask. We'll ask Roland to get back to his therapist and try to help him deal with his underlying mental health issues. But that might not be the end. So we said, what other accommodation should he request? How about we ask that Roland be moved to a different unit away from the dumpsters, away from the noise that triggers his PTSD reactions. That's the best option here. And that, might be perfectly reasonable. There might be open units, or he might be on the waiting list to get a transfer to the next open unit away from the dumpsters that comes up. And there's a good chance that's not a undue burden for the landlord. As far as cost goes, it doesn't change their program, and it doesn't change what they're doing there, it doesn't change their business. So that's why B is the best answer for 2. C says, how about if we soundproof the apartment so the noise doesn't disturb him? And of course, we threw and asked for the landlord to pay for it. It might be a solution if the noise is reduced, but it would probably be a substantial expense, and the landlord's not going to want to pay that substantial expense. I didn't think about this when I wrote the question, but sometimes if it's government subsidized housing, sometimes the government has a higher responsibility to cover costs of accommodations than non-government landlords, but that's a detail I'm not going to get into here today. So anyway, good job helping Roland not get evicted in a difficult situation. A couple of logistics when we're talking about requesting accommodations that I like to make sure we bring up. Some people say, when can I request an accommodation? So the answer is it's never too late to request an accommodation for a disability. Well, up until the point they actually get evicted. Up until the point the sheriff escorts them out the door, that's when it's too late to request an accommodation. But up to that point in time, it's never too late to ask for an accommodation. The landlord should have to entertain the request and engage in a negotiating or interactive process to figure out what's the, is there an accommodation that can resolve the problem? I guess you could be too early with the request. First, you have to have the need before you request, but that wouldn't come up. So I like to just say you can request an accommodation at any time. I've touched on this, but I want to just emphasize it again. The concept in accommodation law, the interactive process. The interactive process means the landlord and the tenant, or their advocates, or their representatives, or whoever, or their attorneys, or case managers, should be engaging in a back and forth, in an interactive, in a give and take, a negotiation about what the accommodation is that's needed and what's reasonable under the circumstances, what can be done, what can't be done. It's not simply a request with a yes or no response. So, the process starts with the tenant requesting the accommodation from the housing provider, and then the landlord responds yes or no. But if the answer is no, then the landlord then has to not just go away, but come back with let's talk about some alternatives, or at least invite the tenant to offer up some alternatives and then discuss those alternatives. So I want to be clear from the landlord perspective. And from the tenant perspective, don't give up if they say no at first. You can compel them to engage. And from the landlord perspective, don't just say no and walk away. So timing wise, we're moving right along. We'll have time for more questions and more hypotheticals from you, I think, at the rate we're going so far. So just want to mention that. A couple slides specifically addressing reasonable accommodations and evictions. It's often that the tenant doesn't come to you or come to me until they already have an eviction notice, or worse, they already have an eviction unlawful detainer lawsuit filed against them. And that's when we first see them. That's not optimal, but sometimes that's, we take our clients as they come to us, right? So just to be clear, the request for accommodation can come at any time. It can come after the eviction notice has been served. It can come after the unlawful detainer has been served. It can come, when the trial for the case is just a few days away. The sooner the better, of course. The less likely it is to be reasonable the later you wait, but it can be used in the eviction context to stop the eviction. If an eviction case has been filed, then the fact that the landlord is not granting an accommodation that they should have becomes a defense to the eviction case. So if push comes to shove, like in Roland's case, the landlord says, we're evicting because he assaulted somebody. That's a violation. And the defense is, well, you should have granted him a second chance. He offered up, a plan or proposal to, that'll hopefully guarantee no further incidents like that. And you should have granted the accommodation. And since you didn't, through the court process, the defense of a failure to accommodate should stop the eviction. And just the note at the bottom, eviction cases move very fast. So anybody threatened with an eviction, find out their situation as best as you can, and then contact us at Legal Aid right away, or Community Legal Services of East Palo Alto also does excellent legal work in these situations. So contact somebody right away. We talked last week, I think, about how fast the eviction cases go. The eviction case, you can give a 3-day notice to terminate a tenant who has a serious lease violation. And then when you serve the eviction lawsuit, the tenant only has 5 days to respond, 5 court days to respond. That's a quick turnaround. The landlord then can get a trial in about 2 or 3 weeks after that. So when all is said and done, like within a month to a month and a half, an eviction case can be going from service of the notice to trial. And so that's why I say these things move really fast, and they can get complicated, right, with our clients with complicated medical issues and complicated mental health issues. So we got to be ready to move fast to help save our clients and keep them in their housing. Monica, just to check in with you, or Lily, that have I missed any questions or chat?
Just actually had one come in from Theodora. Just curious about how, I think, Theodora, let me know if I'm getting this wrong, but just wondering about how fast things are moving during COVID. Like, yeah, I don't know if that was a little bit of a tongue-in-cheek question because things are fast and slow at the same time.
Just being real, like, from my understanding, things have slowed down.
So Theodora, thank you for that. That's an excellent question, because as of March 17th, everything changed, right? So there were eviction moratoriums that completely stopped evictions from happening in the court. But then early October, the courts reopened, and there was a lot of protections for people who couldn't pay their rent because of COVID. So those evictions became a lot more difficult, and we don't see too many of those now. But the cases that are getting filed, and eviction cases that are going forward, are the cases where the landlord is accusing the tenants of violating the lease and doing, serious lease violations. So the courts were open. Now, one thing we do in our eviction cases, we help the client request a jury trial. Tenant in an eviction case does have the right to a jury trial, as opposed to a trial just in front of a judge only. And it was definitely slowing things down because the courts were having a hard time doing jury trials during COVID. Unfortunately, for some people, like the jurors and people getting evicted, the courts came up with an alternative plan to do jury trials. They did the juries would gather at the San Mateo County Event Center where the fairgrounds are held over in San Mateo. And so they had more space. They were doing selecting the juries over there, but then still doing jury trials in the court. But not as many, and it definitely slowed down. But then just recently, as things unfortunately surged and got worse for the pandemic, the court recently just said we're going to hold off any jury trials until January 11th. So I had a case yesterday that would have been scheduled for trial on the 21st and on Monday, this coming Monday, and thanks to the court taking a few weeks off to see where the pandemic goes the next few weeks, there's not going to be jury trial. That case got continued until January 1st. So that was a long-winded answer to try to explain that, yeah, things are kind of screwed up in the courts. But having said that, there are cases being filed. There's the potential that they still go to trial. And we still have to work things out using requests for accommodations and settlements of cases and try to avoid the potential of trial where they can lose and they can, get evicted. So did that answer the question enough or anything specific?
Yeah, for sure. I mean, we've witnessed, I think, a quick process with one eviction that did move forward. So it still, I guess, is happening at that speed.
Yeah, and just a reminder, the tenant has to respond to the unlawful detainer eviction papers within the 5 days. And if they don't respond, then they lose automatically. And then things, the landlord gets the eviction order right away, like after 6 days, 6 business days now. And and then they try to get the sheriff out as soon as possible after that. And the last we heard is the sheriff's department, they have to enforce the orders that they're given. They don't get to decide, with the exception that they always take Christmas week off. They don't evict people during the week of Christmas, as far as we know. Other than that, it can still happen. So, and a lot of misinformation flying around out there. Our clients probably call you and they call me, what about the moratorium? What about the moratorium? It's like, well, that is a thing of the past for a lot of people. So thanks for bringing that question. That's an important point. So one of the most common cases I take on is tenants with mental health disabilities, and their behavior gets them into some form of trouble the landlord's not happy about, and then tries to evict them, and I try to figure out a way to get them out of that. So it's a mental health disability is a disability protected by the law. If their trouble is related to that mental health disability, which it often is, then they're entitled to the accommodation if it's reasonable. A lot of time, the first thing we're asking for is a second chance for the person. And then, like I said, a plan for modifying the behavior usually goes hand in hand with the request for the second chance. You want to be able to assure the landlord and the other residents, the other tenants, that hopefully this was a one-time thing and won't happen again. And we often put the put the tenant on what we call probation, or we agree to what we call probationary tenancy for 6 months, 9 months, a year, where as long as there's no similar incidents that happen, then they get to keep their housing. So what you want to show is that you're going to minimize or eliminate the bad behavior. And if you can reasonably show that, if you have a plan that reasonably shows that, then even tenants who have done some stuff that seems pretty bad, like attacking another tenant, maybe, depending on the severity, of course, that person might be entitled to their second chance under under the law. Now, if the landlord and the circumstances show that this tenant remains a direct threat to the health or safety of other people, even with the accommodation plan you're suggesting, that tenant's not going to be entitled to the accommodation. They're not going to be entitled to the second chance, and they're going to get evicted if the landlord pushes it. You do have to have some assurance to the people, the other tenants, of course, the other residents, of course, that it's a safe situation for everybody. So everybody's well-being does get taken into consideration. So moving to the next slide. Just a couple points. What if the requested accommodation is denied by the landlord or the housing provider? What are some of the options or remedies for the tenant? If it's an eviction situation, then as we talked about, that can be a defense to the eviction case. It could help the tenant actually win the case and stay in the housing. But a lot of times it's not in the eviction context. It might just be a landlord who won't let a tenant move into housing because they have a service animal or something like that. So they're denied housing before they even get in. So tenants can file an administrative complaint with either HUD or the California has a Department of Fair Employment and Housing. And the Department of Fair Employment and Housing is the state agency that enforces the Fair Employment and Housing Act. FEHA, it's called sometimes, FEHA. So they have staff that will take on a discrimination claim, review it, and then sometimes follow it up with an administrative proceeding that brings the landlord in and can try to address the discrimination. So that's one option for tenants. And that one, anybody can go to the Department of Fair Employment and Housing and file a claim. You don't have to have an attorney to do that. The tenant can do it on their own, though sometimes attorneys do get involved. Project Sentinel, I know, helps people. I don't know if anybody, Project Sentinel is on the line here, but I know they help people file with DFEH for discrimination claims. But if you have a more serious claim and you don't want to go to the state agency and put it in their hands, you can get an attorney and file a lawsuit in state or federal court alleging violation of the fair housing laws. And you can ask for an order that enforces the accommodation requested, maybe forces the housing provider to grant the accommodation requested. The legal word for that is injunctive relief, where the court issues an injunction, which is an order for the other side to do something. And of course, there could be money damages, money compensation for harm caused by the fair housing violation. So those are options for people who have their fair housing rights violated. So let's do another hypothetical and some questions to see how I'm doing here today. Another hypothetical based on clients that I've helped in the past. Names changed, of course. So we have Helena. She rents a studio apartment for $1,000 a month. She has bipolar disorder, but she has a full-time job and she's able to pay her rent and her other bills. Sometimes she's feeling good and confident, and Helena decides to stop taking her medication for the bipolar. Unfortunately, this leads to a manic phase that Helena goes through, and she goes on a shopping spree and she spends all her rent money. When she runs out of money, she tries to steal some clothes by trying them on and then runs out the door of the store. The police are called, they catch Helena. She's taken to the psychiatric ward at the local hospital on a 5150 hold due to this bizarre and unfortunately illegal behavior. Rent was due, so now Helena fails to pay her rent. Landlord serves her with a 3-day notice to pay rent or quit by posting it on her door. ignore what we learned last week that you have to do a 15-day notice to pay rent or quit now under the pandemic rules, assuming we're back to normal now. And Helena is in the hospital, so she doesn't see the notice, and she doesn't have the rent money anyway. And the 3 days pass without payment, and the landlord files an unlawful detainer case against Helena based on the non-payment of rent. So that's the hypothetical situation. And let's move on to the questions. Monica will give you the poll. Question number 1, Helena comes to see you. What should you do to help Helena? And number 2, what can the landlord request to make the accommodation more reasonable? Take a minute or so to answer those questions.
And thanks to folks who are already responding. This is our last comprehension check poll of the day. So let's see how many responses we can get. Maybe we'll give it 5 more seconds and then we will close out. All right.
All right, good job with the questions and the answers. Move on to the answer page. So what should you do to help Helena in the situation? Ask for an C is the best answer. Ask for an accommodation that she'd be allowed to pay the rent late for this month on this occasion, and drop the eviction case. Give her a second chance. This is certainly a situation where the problem, the non-payment of rent, was directly related to her behavior, which was directly related to her mental health condition. And so she certainly can seek an accommodation in this situation. B's not a good one, not a good answer to ask that she not have to pay any rent. That's probably not going to be reasonable for the landlord. Though tenants are entitled to a lot of accommodations, getting out of financial obligations completely is not an accommodation that the law recognizes yet. So question number 2, what can the landlord request to make the accommodation reasonable for him? C is the best answer, and this is a little bit of a trick question because the answer I chose was Helena pay a $35 late fee for paying the rent late that month. First of all, I hate late fees. They're punitive. They're often illegal. There's a lot of landlords don't realize it, but they request excessive late fees. They don't do it in a way that's legal. So I fight with a lot of landlords about late fees. But in this case, a $35 late fee under the circumstances might be reasonable. The landlord might have had, some administrative costs to the fact that, serving the notice and things like that can be an administrative cost. $35 is not an excessive amount for a late fee generally. B is not a bad answer, except I threw in the trick word always. B was, can you ask for an accommodation? Can the landlord ask that Helena always pay her rent on time in the future? I think, always and paying exactly on time isn't fair to a person like Helena. And that's why I don't like answer B, but you certainly will get landlords that will want, as a condition of settling this type of a case, make sure it doesn't happen again. Make sure rent is always paid on time. Sure, we'll do a probationary tenancy, but rent has to be paid on time every month going forward. And I try to not let the tenants get into that situation because you know, someone like Helena can easily get into a situation where she's even a little bit late, and you don't want her on a strict schedule where if she's even a few days late, she gets evicted. That just doesn't seem fair or proportional to when I'm advocating for a tenant like her. That's why I don't like answer B. Certainly from the landlord's perspective, it's something it's a reasonable request, but I push back on that one. Let's see, what else do we have? So some people submitted some questions in advance, and I appreciate that. I want to address some of those now, as our time is running towards the end, but we have time to answer a couple questions, and they're good ones. The question was, if a person has a housing voucher and wants to request, so it's a Section 8, a housing Section 8 voucher, a moving to work voucher, and they want to request a larger voucher, which generally means more bedrooms, like a voucher for a 2-bedroom unit instead of a 1-bedroom unit, to support an extra bedroom for a live-in aid. Can the tenant do that? And the answer generally is yes. This is an accommodation that's recognized in the law, and our housing authority here in San Mateo seems to have no problem recognizing this as an accommodation, where the housing authority gives a voucher, again, for a 2-bedroom or a 3-bedroom, so you have an extra, so you can afford an extra bedroom for the live-in aid to live in. I think this ends up in an extra expense for the housing authority, but it's an expense they bear in this situation. If anybody from the housing authority is on the line and wants to help me out on this one, let me know. But so yeah, the caregiver does not become a tenant. They don't have a right to the voucher. They don't have the same rights as a tenant. They're there because basically they're working for the person with the disability to help them. And the extra bedroom is to allow that, to work for them. So in general, the housing authority doesn't care who the caregiver is that moves in, and doesn't do any screening of the caregiver. But a landlord has the right to screen who lives in their building and who lives on their property. So the landlord can actually apply the same screening processes to the caregiver that they would for a tenant moving in. Well, not the same financial screening, because the caregiver is not responsible for the rent, but background screening, like criminal background checks, or the Amber's list or the Megan's list. Sorry, I think it's Megan's list for sexual predator list. They can do background checks like that, and that could possibly keep a caregiver out if they don't meet the landlord's background standards. So I hope that answers the question. Anything else on that? Let's see, what was the next question? So this is a good one. During the pandemic, we actually are seeing this question quite a lot. What about accommodations related to inspections by landlords or others for people who are immunocompromised? So certainly these days, there's a lot of people with health conditions, medical conditions, that make them particularly susceptible to the danger of the coronavirus and COVID-19. And they want to be extra safe, and they do not want any strange people coming into their house, into their home any more than is absolutely necessary, or not at all if possible. So we're definitely getting tenants asking the question, do I have to let the landlord in? Do I have to let their contractors in? Do I have to let the pest control guy in? Do I have to let the real estate agent in, et cetera? So in general, again, the tenant's entitled to whatever the accommodation that is needed under the circumstances. And just a reminder from last week, random inspections by a landlord are never allowed. The landlord has to have a specific legitimate reason before they can come into the unit at all. So if the landlord does have a legitimate reason that they really need to come into a unit and the person, doesn't want anybody coming into the unit, I think at that point, the landlord has to take into consideration the condition and accommodate it as much as possible. At that point, we just hope that the tenants and the landlord can work together. On the landlord's end, it's limiting the people who come in the unit, taking all the precautions necessary, wearing masks, maybe face guard, gloves, hand sanitizer, disinfecting, not touching anything that doesn't need to be touched, keeping it as short as possible, maybe doing it at a time when the tenant can be out of the unit if that's possible. Just the parties really need to work together, and the landlord certainly does have to accommodate the tenant's needs and not endanger them. But there might be, maintenance that is needed on the property, and we don't know how long this pandemic is going to last. Certainly longer than we expected at first, and some things can't wait. So the landlord might still have a right to do that maintenance, even despite the tenant's needs. So they just have to work together to make it work. And I hope that answered that question. I was gonna, if we have any extra time, we're right exactly at 90 minutes, I think. Well, we're right at 10:30 anyway. There was one other question that came in after I had finished the PowerPoint, and I'll address that question. And the question was, we have a tenant with an emotional support dog. And so I'm assuming this is an affordable housing provider here who acts as the landlord. But there's been issues with the emotional support dog and the tenant not keeping the dog on the leash, and the dog actually causing problems for another tenant, another resident, even attacking that person. Kind of like our example in. I'm sorry, take that back. But anyway, so the dog attacks somebody and it's off the leash, and the landlord is asking, what do I do in this situation? How do I address this situation? And so this is where we get into the back and forth, the what's reasonable, what's not reasonable. Is it a threat? Is it not a threat? Is it an unreasonable threat? The tenant, we start with the tenant has the right to have the emotional support dog if it's supported by the doctor, but you don't have the right to have an animal that is causing too much problem for the other residents or the staff. So one of the requirements is that they're asking is, okay, keep the dog on the leash whenever the dog is out of the home. I don't think that's an unreasonable request for a dog owner to keep the dog on a leash. That's pretty common depending on where you are around the county or anywhere. So there's a violation when the dog is off the leash, and then you get the increased problem when the dog actually attacks somebody. So now you're getting into the behavioral problem where you kind of got to start asking, the tenant's going to have to start asking for the second chance, assuming it was a serious enough attack where it's potentially an evictable offense. That tenant, is going to have to request for an accommodation for, okay, please give me a second chance. I promise that the dog will always be on a leash going forward. If the dog caused any harm, they better, figure out how to address that or resolve that. And then it's going to be a question of, does that acceptably minimize the problem with that particular animal? If it does acceptably minimize the problem, then the tenant's gonna claim they have the right to that accommodation. If the tenant is really concerned, and if the landlord is really concerned that this is going to be an ongoing problem, the landlord might press it further. From our perspective, we're tenant advocates and advocates for people with disabilities. So, I don't have specific advice on how to evict a tenant that's, out of control or their dog is out of control. Most landlords and housing providers have their own legal counsel they can go to for those questions. So, but I hope that kind of answered that question. Do we, Monica, or I see Morgan on the screen. If you unmute and ask the question, I'd love to hear from you.
Hi, yes, good morning, David. That was actually my question. We have an incident with a tenant. We've asked them to put their dog on a leash 2 times in the past, and just found out that their dog actually attacked a bystander. And so I just wanted to, get your advice on, I'm in the process of writing up a lease violation right now, but just wanted to kind of get a sense. Definitely want to accommodate her and, consider their situation, but just wanted to see how kind of far we should accommodate these types of situations.
Yeah, no, I totally appreciate. This is not the first time I've heard of a companion or a service dog or a companion dog causing problems. I should say the service dogs tend to be trained. They have special training and specific training, so you don't see the service dogs necessarily causing the problem so much. They're usually, before they get to that status, they've had to go through some special training. But the emotional support animals, like we're talking about, they don't have any special training. They're just there because of the comfort they provide to the person. So, when I was trying to answer the question, I think maybe you notice I was dancing around, not specifically telling, from your perspective, I can't tell you what action to take against the tenant, but I'm trying to respond from the tenant's perspective and what the law is. And that's how I was trying to answer it is, I think it's reasonable certainly to require that the animal's on the leash. And when it's not on a leash, that can be a problem. I mean, any dog can be intimidating to a person that runs up to, even a small dog can be intimidating to somebody else. Another tenant there might have PTSD or anxiety and might have, fear of dogs in their past. And so even a small dog can cause them problems. So certainly reasonable to ask them to keep the dog on the leash. And of course, attacks can't happen. It depends on the seriousness of the attack. And, how can the tenant assure that this is not going to happen again in the future? So again, I know I'm kind of dancing around the question because, like I said, I'm the tenant advocate and I'm going to be trying to tell this tenant, but I would be advising this tenant, how can you avoid, getting evicted? How can you avoid trouble? What are your legal responsibilities? Not just your rights, but your responsibilities. So.
Thank you. No, that was a great answer. I appreciate it. Thank you.
All right. Well, thanks for letting me stay a tenant advocate and dance around it a little bit. All right. Anybody else questions or chime in or examples? We have a little bit of time.
I think we had one come in about a veteran with an eviction on his credit report. Did you see that one?
I haven't been checking the chat, but that's
okay.
a good
I can go, or actually, do you know what? Sorry, I don't know your first name, but the person who submitted, do you want to go ahead and hop off mute if you're still on, and maybe you can explain it a little bit more? Otherwise, I'm happy to read what came through on the chat.
Yeah. All right. I think I get the gist of the question also.
You do? Okay, great.
Well, I'm sorry. Go ahead and read it to me just to make sure I have a little bit.
Okay,
more.
and so for people, so you don't have to go hunting around in the chat. It says there's a veteran who has an eviction on his credit report. Complex stated to retract, stating COVID-19 is preventing them from the removal. The veteran left due to military orders and an incident that happened in 2015. What are his options because he can't find affordable housing based on this? You unmute too. I saw that. So
Okay,
that's that.
thank you.
Okay. Oh, you know what? We can hear you. You did it.
Yeah.
Anything else you want to add to that?
Right now he is currently housed. He's trying to look for other housing, and that happened in another state. Okay, so he is in California, but the thing is he's trying to find a cheaper unit because of COVID. He lost his employment, and so they got to go into a cheaper unit to stay stably housed. But in trying to locate housing, it keeps coming up on his credit report, and he has disputed it. And I have it in writing where the complex has stated that they, it says they will dismiss the case as they did from the one from 6/2015. But the thing is, they also stating that COVID is part of the issue why they're unable to get anyone in the courts, whatever, to lift this from him so that it could be immediate. I don't think it could be immediate, but at least if they make the steps to undo it. So what is his options?
Yeah, that's a good question. Thanks for that. A lot of people, you know, that go through the eviction process, if things don't go well, they can end up with an eviction on their record. And the problem is what eviction on the record means is not necessarily just, it might show up on a credit report. And that's one problem, because then it shows up anytime anybody runs the credit report, the case might show up on there, especially if there was like a money judgment. But an eviction case that the tenant loses can end up in the public court records. And the problem with that is that, you know, that really doesn't go away, and it's not easily, you don't easily get rid of it. You don't purge it, you don't expunge it like you can a criminal conviction sometimes. It can be something that can follow the tenant for a long, long time, if not forever, because it's a court record. It's a case that happened. Court records are public records. And the current state of the law is if the tenant loses the case, then it does become a public record. Fortunately, California has good laws where if the tenant does not lose the case, then it does not become a public record. So if there's no judgment against the tenant, then it should not end up on the credit report, and it shouldn't be a public record. But there are landlord agencies or landlord support agencies that will track, you know, the public court records, and then they keep track of, you know, who's got an eviction, who doesn't. And then a lot of landlords use that as a criteria for, you know, whether they're going to rent to somebody or not. And to be honest, there's not a good answer to of getting rid of an old eviction on the record. You know, if the landlord is willing to file some papers, sometimes they can file something that makes it look like the case was dismissed. But once it's a public record, it's kind of out there already. And especially 5 years old, like this situation, it's possible that this is not going to go away from the person's record, that it's going to follow them. So having said that, they have to go to, you know, plan B is, you know, how do you find housing when you do have an eviction on your record? You know, since we're talking about accommodations, it's possible that if they could tie the eviction back to their disability, maybe they could ask for an accommodation that it not be used against them, because the eviction, you know, was unreasonable and was related to their disability, and maybe they just couldn't respond in time because of their disability.
Well, they were relocating from one state to the other with military orders. And so the actual time of the service, the time that he was actually supposed to be served, he was actually in California. So he wasn't physically served.
Yeah, that's really unfortunate. So it's like nothing they did wrong necessarily. And then it's even in another state. So
Yeah.
it's further removed. It's also harder to deal with. So, but that's not really disability related. That's just their circumstances. We don't know the whole underlying reason the case was filed in the first place. But so it's tricky. So, I don't have a good answer for how getting the eviction off the record. What I advise tenants is, there's some landlords will not rent to people with an eviction on your record, but a lot of landlords don't check that. A lot of landlords don't care. A lot of landlords, all they care about is, can you pay the first month's rent and the deposit, because they've got an empty unit. So some landlord, you got to find the landlords that don't hold that against the tenant. So I know that's not a great answer. It's not the answer you want to hear, but I don't have a good answer for how you get rid of an old eviction. Unfortunately, I hear that.
I'm gonna hop in just real quick because I know some folks are saying that they need to hop off. I just wanted to we'll stick around if David can and keep these conversations going, because I think they're really helpful, and we've got him here, so let's use them. But I just wanted to let you all know, aside from my incessant bugging you to fill out the survey that I'm posting in the chat, do it one more time. Why not? I really wanted to particularly flag an opportunity to give us feedback in the section where you can write stuff on the survey, with a mind, with an eye towards our next training, which is going to be a fair housing training. Building on the stuff that David has presented, we're going to have a presenter from Project Sentinel come to talk specifically about fair housing. And the presenter, really wants to hear from you all, much like David did, what you're seeing, what your questions are, so she can tailor her information to your needs as best she can. So please feel free to use the survey that we're sending around to give feedback on the tenants' rights training, but also in the section that asks about suggestions for upcoming training. Feel free to just drop any requests you have for fair housing questions or topic areas in there. You can also feel free to just throw some stuff in the chat right now if that feels easier. And we really appreciate that. And the announcement for that will be coming out to you pretty soon, and it will be in mid-January. So that's my little aside as folks are needing to hop off. And then David, do you have time to just stick around a little bit longer in case people still have questions?
I sure do. Miss, I think it's Flagler, you and I were just talking about your situation. Maybe feel free to call me and we can talk offline, maybe more details about the person's situation. Maybe we can think of some other options for them. But otherwise, the answer is, yeah, if anyone else has other questions or examples.
What number?
So the last slide on the screen has my number at the bottom there. That's my direct line, the 517-8922 number.
Thank you.
And again, my invitation from last week remains open. Call me anytime if you want to talk about clients or even your own personal rental situations. Happy to chat with you about that. And for clients, of course, give them our intake line. That's the most efficient way for them to get services from us, not my direct line.
Awesome. Thank you, David. I think we had a couple of pending questions in the chat. I saw one regarding whether there's a special process for eviction if someone's on military orders. And then there was another question earlier in the chat going back to service and support animals. What if a service or support animal soils like carpeting in a common space, like a hallway? Is that something that the landlord or the property owner can pay or request that a tenant pay for?
Okay, so I think the first question was, if you're in the military, do you get other special rules or laws for people in the military if there's an eviction? It probably, off the top of my head, the answer is not really. If they're renting a regular, rental situation, private rental situation, something in the back of my mind is telling me that there might be a protection for military service, but I'd have to look it up. I'm not familiar with what it is off the top of my head. I haven't had to use that. If they're in military housing, like on a base or something, I have no idea what the rules are for that. I can't imagine they evict people in the military from their military housing, but there's got to be special rules for all that I wouldn't have anything to know about. If it's a veteran housing or housing for veterans, there's a good chance it's federally subsidized. Any federally subsidized housing usually comes with the protection of you get to keep living there unless you commit a serious lease violation, and then they have to go through the whole due process in general, like any government subsidized housing, federally subsidized housing, including veteran housing. So sorry, it's not a very good answer on if somebody's in the military in a private landlord setting. I'd have to look that up. I don't know that off the top of my head. The second question was, yeah, what if the service animal or the support animal causes damage? The tenant is responsible for the damage, financially responsible for the damage caused by the animal. So yeah, that's just the short answer. Now how much damage they cause could create, the bigger problems of not just paying for it, but, is it creating a bigger problem that the landlord really needs to stop, not just from a financial standpoint, but is it causing a disturbance to other tenants or staff? But in general, the tenant is responsible for the cost of the accommodation. Anything else? I see a question, is there a fee to apply for an ESA, an emotional support animal? So the answer is no. The landlord cannot charge extra fees or costs or rent or deposits for any animal that's there as an accommodation for the person's disability. It's not considered a pet. It's considered like a medical device, but it's a living, breathing, furry medical device. So the question also asks, what is a reliable website to obtain the document? Like I said, I don't think there's any, there's no application. Well, so maybe your question isn't, is there apply to the landlord, but how do I get the emotional support animal like certified as an emotional support animal? There are websites, online websites that will sell the service of you pay them a fee and they send you a certificate that says you have an emotional support animal. They might send a tag, they might send a card, they might send a little vest or something for the dog or the animal to show that it's an emotional support animal. On the one hand, these are not legitimate. This is not the same as a doctor saying, I hereby, verify that you're disabled and you need the animal. This is just a site making some money off of people who need emotional support animals. But having said that, there can be value to the person with the disability and the emotional support animal in having something official looking. When the dog that has the vest on, it's like, then you recognize, when the person goes into a store, for example, and say, hey, you don't bring animals into the store, but it's got the emotional support animal. It's announcing to the world that this is not just a pet that I'm tagging along. This is my emotional support animal. So it can stop people from, hassling you more likely in public than with the landlord. So I don't know if that answered the question. I tried to answer the question. So, you might pay $100 for something that has no legal significance, but it might still add some benefit out there in the real world.
David, can I tag on to that briefly?
Please.
There is an organization called Disability Rights California, and they have a fact sheet on rights to service and support animals in housing. That includes some sample letters. So like if someone has a doctor or a therapist who wants to know, what do I put in the letter? What do I not put in the letter? This is a reputable organization that provides a sort of sample template for folks to reference. And it is free and available.
Yeah, no, that's excellent. Disability Rights California is one of the top, disability rights law offices in the state. So certainly their resources are going to be good. San Mateo County has a great organization. If anybody's on the line with us today, and I'm drawing a blank with the name of it, but there's a great disability rights support group here in San Mateo County also. My apologies for drawing a blank on the name of the organization. I wouldn't be surprised if they would have resources also to help with that. Thank you everybody for hanging in there and participating and listening. And again, don't hesitate to call me to talk about specific cases and put our heads together and see how we can help people stay in their houses, stay in their homes and live comfortably.
Thank you so much, David, for taking all of this time to do these two-part training, answering all of our questions. I know I speak for everyone when I say we so appreciate it. So yeah, definitely folks, feel free. He said we can bug him, so go forward with your questions. And thank you everyone for making time to be here today and for bringing all of your great questions. We really look forward to seeing you all in the new year that's hopefully going to be so much more awesome than this last year in so many ways. So we'll kickstart that with our mid-January fair housing training, get the year started right with our fair housing stuff. And thank you again, Dave, for all the information and for laying such a foundation for our future trainings. So take really good care. Let us know what your topics and questions are. Never hesitate to reach out to home base as well. Yeah, have good holidays and otherwise a cozy rest of your December, everybody.
Thank you, Lily. Thank you, Monica. Happy holidays to all.